By Mark Allen Wasmuth, page 1 of 62. The Fraud of Bank Loans. The Fraud of Bank Loans. And Theft of Labor. By the U.S. Banking System. Mark Wasmuth. The Rabbit Hole Research Group, consistently digging for the truth. By Mark Allen Wasmuth, page 2 of 62. The Fraud of Bank Loans. 1. Definitions. 2. U.S. Code and Constitution on Debt. 3. Modern Money Mechanics by the Federal Reserve Bank of Chicago 19614. Modern Money Mechanics by the Federal Reserve Bank of Chicago, revised 1991. 5. Two Faces of Debt, Federal Reserve Bank of Chicago, Reverend ed. September 1992. 6. Money and Banking 6th edition 1976. 7. I Bet You Thought by the Federal Reserve Bank of New York, December 1977. 8. Money, Banking and Monetary Policy by the Federal Reserve Bank of Dallas, May 2007. 9. Your Money and the Federal Reserve by the Federal Reserve Bank of Minneapolis 196010. Case Law on Banking, First National Bank of Montgomery vs. Jerome Daly. 11. National Currency ACT 186413 Stat 9912. HJR 192 Public Law 73 to 10 June 5, 1933, 13. Generally Accepted Accounting Principles GAAP 2003 edition 14. Senate Document 43, April 17, 1933 15. The 7 Requirements of a Valid Contract 16. First Bank Inc. FDIC Financial Report 1017. Huntington Bankshares Inc. FDIC Financial Report 10. Part 1, Part 2, Part 3, Part 4, Part 5, Part 6, Part 7, Part 8, Part 9, Part 10, Part 11, Part 12, Part 13, Part 14, Part 15, Part 16, Part 17. Appendix. Definitions. Part 1. 19. Lender. 1. 22. Money. 1. The Fraud of Bank Loans. 18. Borrower. 1. To obtain upon loan from the owner or other person having the right of disposition, to engage the use of money by contract state. Ex rel. Kimball vs. School Dist. 13 Neb 82, 88 Ballantines' Law Dictionary. UCC 1-201 24 means a medium of exchange currently authorized or adopted by a domestic or foreign government. The term 2. I Bet You Thought. David H. Friedman, Federal Reserve Bank of New York, 4th ed. 1984, states, money is anything that has value that banks and people accept as money. Money does not have to be issued by the gover. See Part 7 of this affidavit. 23. Deposit. Title 12 U.S.C. Section 1813 L1 Definition of Deposit under Federal Deposit Insurance Act. 1. The unpaid balance of money or its equivalent received or held by a bank or savings association in the usual course of bizthrift account, or which is evidenced by its certificate of deposit, thrift certificate, investment certificate, certificate of indebtedness, or other similar name, or a check or draft drawn against a deposit account and certified by the bank or savings association, or a letter of credit or a traveler's check on which the bank or savings association is primarily liable, provided that, without limiting the generality of the term, money or its equivalent, any such account or instrument must be regarded as evidencing the receipt of the equivalent of money when credited or issued in exchange for checks or drafts or for a promissory note upon which the person obtaining any such credit or instrument is primarily or secondarily liable, or for a charge against a deposit account, or in settlement of checks, drafts, or other instruments forwarded to such bank or savings association for collection. 24. Credit banking. 3. Bookkeeping entry representing a deposit of funds into an account. Thomas P. Fitch, Barron's Business Guide Dictionary of Banking Terms. He from whom a thing is borrowed. The contract of loan confers rights, and imposes duties on the lender. 1. The lender has the right to revoke the loan at his mere place. 9 Cowan, R. 687, 8 Johns. Rep. 432, 1T. R. 480, 2 Camb. Representative 464, and is deemed the owner or proprietor of the thing during the period of the loan. Bo 20. Tenant. 1. One who occupies the premises of another in subordination to that other person's title and with his assent express or imply. 32. MJ 1st L and T Section 2. Broadly, any person having a tenancy. 2. A tenant, although having exclusive possession, charge and control, is not owner of the land within a statute making it U.N.O. 2 ALR 799, S95 ALR 1099 Ballantines' Law Dictionary. 21. Owner. 1. One who has complete dominion over particular property. 42 MJ 1st Prop Section 37. The person whom the legal or equitable T. Anno. ALR 779, S.95 ALR 1086. In common understanding, the person who, in case of destruction of property, must sustain the 42 MJ 1st Prop Section 37. 2. As to the meaning of owner, as used in statutes relating to the assessment and collection of taxes, see Anno. 2 ALR 792 Ballantines' Law Dictionary. By Mark Allen Wasmuth, page 3 of 62. U.S. Constitution on Debt. 25. The Fraud of Bank Loans by Mark Allen Wasmuth, page 4 of 62. The U.S. Constitution Article 1 Section 10 of the U.S. Constitution states, 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. 2. It is impossible to pay a debt using Federal Reserve notes. Federal Reserve notes are debt instruments as evidenced by the word note, as in Federal Reserve note that is on the dollar bill. 1. Note is a debt instrument. Black's Law 4th edition. 2. Federal Reserve notes come into existence only by creating debt. At the sale of T-bills, T-notes, T-bonds. B. Fractionalized banking on deposits. C. Creating loans. Modern Money Mechanics by the Federal Reserve Bank of Chicago. 1961. Part 3. The Fraud of Bank Loans by Mark Allen Wasmuth, page 5 of 62. The full document is available upon request. 26. The UCC 3-102(c) Regulations of the Board of Governors of the Federal Reserve System and Operating Circulars of Th. Article. To the extent of the inconsistency. 27. Page 3 states, 1. The actual process of money creation takes place primarily in banks. 2. They are book entries which result from the crediting of deposits of currency and checks and the proceeds of loans. And 3. Banks can build up deposits by increasing loans and investment. 28. Page 4 states, 4. Bankers discovered that they could make loans merely by giving borrowers their promises to pay bank notes. In this 29, page 6 states, 5. Of course, they do not really make loans out of money they receive as deposits. If they did this, they would be acting Juby created. 6. What they do when they make loans is to accept promissory notes in exchange for credits they make to the borrowers. 30. Page 7 states, 7. 3. Expansion take place only if the banks which hold these excess reserves increase their loans or investments. Loans are made by crediting the borrower's deposit account, i.e., by creating additional deposit money. 31. Page 8 states, 8. The lending banks, however, do not expect to retain the deposits they created through their loan operations. 9. Loan-created deposits may be transferred to other banks, but they remain somewhere in the banking system. 10. Any deposit he receives is new money to him, regardless of its ultimate source. 11. Deposits expansion can proceed from investments as well as loans. 32. Page 11 shows a chart and states, 12. Thus through stage after stage of expansion, money can grow to a total of 6 2/3 times the new reserves supplied to Th. 13. ellipsis dot. As the new deposits created by loans at each state are added to those created at all earlier stages and those sub 33. Page 26 states, 14. These new loans add to banks' deposits. Modern Money Mechanics, by the Federal Reserve Bank of Chicago. 1961. Part 3. The Fraud of Bank Loans by Mark Allen Wasmuth, page 6 of 62. Modern Money Mechanics. 35. 1. The Fraud of Bank Loans, by the Federal Reserve Bank of Chicago. Revised 1992. Thus through stage after stage of expansion, money can grow to a total of 10 times the new reserves supplied to the banking system. The total amount of expansion that can take place is illustrated on page 11. Carried through to theoretical limits, the initial $10,000 of reserves distributed within the banking system gives rise to an expansion of $90,000 in bank credit, loans and investments, and supports a total of $100,000 in new deposits under a 10% reserve requirement. The deposit expansion factor for a given amount of new reserves is thus the reciprocal of the required reserve percentage, 1.10 equals 10. Part 4. By Mark Allen Wasmuth, page 18 of 62. Page 11 states, the full document is available upon request. 34. Page 8 states, Modern Money Mechanics, the Fraud of Bank Loans, by the Federal Reserve Bank of Chicago. Revised 1992. Part 4 by Mark Allen Wasmuth, page 19 of 62. Money and Banking. The full document is available upon request. 37. Chapter 6, page 144 states, 6th edition 1976. Part 6, by Mark Allen Wasmuth, page 24 of 62. The Fraud of Bank Loans. 1. Most people suppose that a bank lends the deposits of its customers. In fact, however, no bank ever lends its deposits. Money and Banking. 6th edition 1976. Part 6, by Mark Allen Wasmuth, page 25 of 62. The Fraud of Bank Loans. Money and Banking. 6th edition 1976. Part 6, by Mark Allen Wasmuth, page 26 of 62. The Fraud of Bank Loans. I Bet You Thought, by the Federal Reserve Bank of New York. December 1977. The full document is available upon request. 38. Page 5 states, 1. Money is anything generally accepted medium of exchange. Not simply coin and paper currency. Money does be issued by a government or be in any special form. 2. Demand deposits are the nation's most common form of money, comprising about 3/4 of all mon. 39. Page 7 states, 1. But that approval doesn't make cash any more real than checkbook balances. 40. Page 19 states, 1. Checkbook money is created by currency deposits. 2. Commercial banks create checkbook money whenever they grant a loan, simply by adding new deposit $IOU. Part 7, by Mark Allen Wasmuth, page 27 of 62. The Fraud of Bank Loans. Money, Banking and Monetary Policy. The full document is available upon request. 41. Page 11 states, 1. Banks actually create money when they lend it by the Federal Reserve Bank of Dallas. May, 2007. Part 8, by Mark Allen Wasmuth, page 32 of 62. The Fraud of Bank Loans. Money, Banking and Monetary Policy, by the Federal Reserve Bank of Dallas. May, 2007. Part 8, by Mark Allen Wasmuth, page 33 of 62. The Fraud of Bank Loans. Your Money in the Federal Reserve System, by the Federal Reserve Bank of Minneapolis. 1959-1960. The full document is available upon request. 42. Page 8 states, 1. Commercial banks, however, when providing additional funds to borrowers, also add to the total amount of M43. Page 9 states, 1. When the borrower receives cash or deposit credit, the amount of money available for spending is increased too. A promise to pay has, in fact, created new spending money. Part 9. By Mark Allen Wasmuth, page 35 of 62. The Fraud of Bank Loans. Your Money in the Federal Reserve System. By the Federal Reserve Bank of Minneapolis. 1959-1960. Part 9. By Mark Allen Wasmuth, page 36 of 62. The Fraud of Bank Loans. Case Law for Credit Loans and Void Contracts. Part 10. By Mark Allen Wasmuth, page 39 of 62. The Fraud of Bank Loans. Case Law for Credit Loans and Void Contracts. The reference in the suit of any statute, code, ordinance, and/or act of law established or ordained by the public officials who have taken an oath to serve as public trustees, shall be used only for the purpose of clarifying to respondents the rules of engagement for their service to the sovereigns. 44. In the federal courts, it is well established that a national bank has not power to lend its credit to another. Farmers and Miners Bank v. Bluefield Nat. L. Bank, 11 F2D 83, 271 U.S. 669. 45. A national bank has no power to lend its credit to any person or corporation. Bowen v. Needles Nat. Bank, 94 F925 36 CCA 553, certiorari denied in 20S Court 1024, 176 U.S. 682, 44 LED 637. 46. A bank may not lend its credit to another even though such a transaction turns out to have been of benefit, which would look like a catalog of ships. Emphasis added. Norton Grocery Company vs. People's Nat. Bank, 144 SE 505. 151 VA 195. 47. Checks, drafts, money orders, and bank notes are not lawful money of the United States. State v. Nealon, 73 Pac 324, 43 or 168. 48. Neither, as included in its powers not incidental to them, is it a part of a bank's business to lend its credit, might. If it received compensation and was careful to put its name only to solid paper, make a great deal more than any lawful interest on its money would amount to. If not careful, the power would be the mother of panics. Indeed, lending credit is the exact opposite of lending money, which is the real business of a bank, for while the latter creates a liability in favor of the bank, the former gives rise to a liability of the bank to another. I. Morse. Banks and Banking 5th ed. Sec. 65, McGee, Banks and Banking, 3rd ed. Sec. 248. American Express Company vs. Citizens State Bank, 194 Northwest 429. 49. It is not within those statutory powers for a national bank, even though solvent, to lend its credit to Año the Federal. Intermediate Credit Bank v. L. Harrison, 33 F2D 841, 842 1929. 50. There is no doubt but what the law is that a national bank cannot lend its credit or become an accomoda national. Bank of Commerce v. Atkinson, 55 E. 471. 51. A bank can lend its money, but not its credit. First Natal Bank of Tallapoosa v. Monroe, 135 GA 614, 69 SE 1124, 32 LRA NS 550. 52. The bank is allowed to hold money upon personal security, but it must be money that it loans, not its Seligman, v. Charlottesville Nat. Bank, 3 Hughes 647, Fed. Case Law for Credit Loans and Void Contracts. Part 10. By Mark Allen Wasmuth, page 45 of 62. The Fraud of Bank Loans. National Currency ACT 1864. 13 Stat 99, SEC. 28. And be it further enacted, that it shall be lawful for any such association to purchase, hold, and convey real estate as follows. 1. First. such as shall be necessary for its immediate accommodation in the transaction of its business. 2. Second, such as shall be mortgaged to it in good faith by way of security for debts previously contracted. 3. Third, such as shall be conveyed to it in satisfaction for debts previously contracted in the course of its dealings. 4. Fourth, such as it shall purchase at sales under judgments, decrees, or mortgages held by such association, or shall purchase to secure debts due to said association. 5. Such association shall not purchase or hold real estate in any other case or for any other purpose than is specified in this section, nor shall it hold the possession of any real estate under mortgage, or hold the title and possession of any real estate purchased to secure any debts due to it, for a longer period than 5 years. SEC. 53. And be it further enacted, that if the directors of any association shall knowingly violate, or knowingly permit any of the officers, agents, or servants of the association to violate any of the provisions of this Act, all the rights, privileges, and franchises of the association derived from this Act shall be thereby forfeited. Such violation shall, however, be determined and adjudged by a proper circuit, district, or territorial court of the United States, in a suit brought for that purpose by the controller of the currency, in his own name, before the association shall be declared dissolved. And in cases of such violation, every director who participated in or assented to the same shall be held liable in his personal and individual capacity damages which the association, its shareholders, or any other person, shall have sustained in consequence of such. Part 11. By Mark Allen Wasmuth, page 46 of 62. 69. 70. The Fraud of Bank Loans. HJR 192 Public Law 73-10. June 5, 1933. That every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payments in gold or a particular kind of coin or currency, or in an amount in money of the United States measured thereby, is declared to be against public policy. 72. All coins and currencies of the United States, including Federal Reserve notes and circulating note 71. 73. The Fraud of Bank Loans. Part 12. By Mark Allen Wasmuth, page 51 of 62. Generally Accepted Accounting Principles, GAAP, Title 12 U.S.C. Sec. 1831 N.A. 2. Banks must follow the Generally Accepted Accounting Principles GAAP. This includes but not limited to the matching principle Wiley 2003 Section 41 STA 1. Anything accepted by a bank for deposit would be considered as cash. 2. Cash must be available for a demand withdraw. 74. 75. The Fraud of Bank Loans. Part 13. By Mark Allen Wasmuth, page 54 of 62. Generally Accepted Accounting Principles, GAAP, The Fraud of Bank Loans. Part 13. By Mark Allen Wasmuth, page 55 of 62. Senate Document 43 Stone 73 Congress 1 Session. April 17, 1933. Also known as Senate Resolution 62 page 9 states. 1. The ultimate ownership of all property is in the state, individual so-called ownership is only by user. And use must be in accordance with law and subordinate to the necessities of the state. 76. The Fraud of Bank Loans. Part 14. By Mark Allen Wasmuth, page 56 of 62. The 7 Requirements of a Valid Contract. Part 15. By Mark Allen Wasmuth, page 60 of 62. 77, 78, 79. The Fraud of Bank Loans. Essentials of a valid contract. 1. An agreement will be enforced when the following essential elements exist. I. Offer and acceptance. There must be an offer by one party and an acceptance of it by the other. E. Intention to create lawful relations. E. Capacity of the parties. Each party must have the legal capacity to make the contract. IV. Consent must be genuine. The consent must not be obtained by fraud, or duress such as death threats if the contract is not entered into. V. Consideration must be present. V. Legality of object. The object of the contract must not be one of which the law disapproves. V. Possibility of performance. 2. All the above elements must be present. If one or more is absent, the contract will be either I. Void, E. Voidable, or E. Unenforceable. 3. Void contracts are destitute of lawful effect, that is, they are not contracts, and agreements of this kind do not confer legal rights on the parties thereto. America's Jurisprudence 2nd Sections 50, 51 and 52, Actions, on page 584. 1. No action will lie to recover on a claim based upon, or in any manner depending upon, a fraudulence was a party. There is a legal maxim of law, a self-evident truth, that says, a thing similar is not exactly t. First Bank Inc. FDIC Report Part 16. By Mark Allen Wasmuth, page 61 of 62. The fraud of bank loans. 80. This FDIC report for First Banks shows, 1. They have $393,816,000, line 26, in total capital but have loaned out $2,405,846,000, line 7, to its customers. I. They have loaned out 6.1 times more money than they have if they liquidated or mortgaged all their assets. 2. It shows that net loans, line 7, are a part of total assets, line 2, which matched total liabilities and capital, line 15. Huntington Bankshares Inc. FDIC Report Part 17. By Mark Allen Wasmuth, page 62 of 62. The fraud of bank loans. 81. This FDIC report for Huntington Bankshares shows, 1. They have $4,444,128,000, line 26, in total capital but have loaned out $38,146,356,000, line 7, to its customers. I. They have loaned out 8.5 times more money than they have if they liquidated or mortgaged all their assets. 2. It shows that net loans, line 7, are a part of total assets, line 2, which matched total liabilities and capital, line 15.